understand it, we're going to start picking the jury Wednesday at 9 a.m. Nashville time. So Mr. Chen will be transported to Davidson County sometime Tuesday. The jail, as I understand it, is pretty much adjacent to the courthouse. There will be a transport issue there. We'll, depending on how the questionnaire discussion goes, that will determine what happens on Wednesday. But at some point, we'll start picking the jury, actually engaging them in conversation, hopefully have that finished up by Thursday. Then the jurors will be sent home to pack, arrange their affairs, and the way I understand it, they'll be met Sunday in Nashville with our deputies. We'll then take them down to the hotel here. They'll be checked in, accommodated, be brought to court Monday, and that's when they'll be sworn in. They will not be sworn in Nashville. As soon as you swear the jury in, that's when they have to. Stay together. That'll happen on Monday. And then after that, it's just the regular routine sequester jury. That's the overview of it. Are there any specifics the parties want to discuss more than that?
So the court
will
the court be instructing the jurors, and at 14 is what the court's decided. Will the court be instructing the jurors on Thursday that they are not to read?
Absolutely.
Okay, and then they would have to verify Monday morning that they have not done that.
Correct.
Okay.
Anything else, Mr. West? At this moment?
Not regarding the jury selection.
Okay. Just a fluid thing. If something happens, then we can always, we've been really good in the past about contacting each other during the trial to see if any issues pop up and handling them before they develop into a major issue. So we'll just continue that process throughout this trial. All right. Any other questions about the logistics at this point?
No, except for I had mentioned to Your Honor that I don't believe we have to follow the motion. We had it prepared and I've read it. I don't know what happened to it. But both parties have agreed, if the court would agree, to keep at least one alternate juror sequestered throughout deliberation. In the event that deliberation is lengthy and something were to happen to a juror, especially with them being further from home, just to ensure that if there is something that happens, there's another alternate that's been sequestered and can step in. I believe we're all agreeable for at least one, if not both of them, to remain in the courthouse sequestered.
I think that's a great idea. I think that, okay. I'm curious why we haven't done that before. Always got to start somewhere. We'll start with this. Okay. Any other logistical issues? Sheriff, you're here right now. While you got the parties, I don't know if your team wanted, before we got to the actual substantive hearings today, if you had any questions or anybody from your team had any questions that wasn't covered.
I think we're good now, Judge.
Okay.
We'll be sure and bring them to the court's attention.
Okay. And again, yeah, if these things, if something pops up, the communication issue with Davidson County Jail or the courthouse, just let us know and we'll do our best to resolve it. All right. Thank you all. Any particular order of the motions?
Judge, I would say while we're on jury issues, I would ask to go ahead and get into the motion for a jury questionnaire to be given to the jurors.
Have you heard, Mr. West?
Yes, Your Honor. Originally, I believe the plan for a jury questionnaire was to get the questionnaire out to prospective jurors at a time that they were being summoned. Obviously, that did not happen in time. So I believe the questionnaire that I presented to the court within the motion probably isn't pragmatic or reasonable anymore, because there's no way to get it out into the mail and get those answers back within the known time, or at least I don't think there is.
There's no way we could do it before next Wednesday for sure. The concept I was thinking about, and I understand the state rejects the questionnaire overall, if we could possibly give this to them in the morning, let them fill it out, we could look at it in the afternoon, I don't know if that really saves the time that questionnaires are designed to save.
Well, it does. So one, it certainly does save time, but two, and more importantly, it gives an opportunity for prospective jurors to be honest. I believe the literature says that jurors tend to be more honest on paper than they are in front of a crowd of other people. You know, you ask a crowd of people, have you ever been arrested before? You know, people are hesitant or reluctant to say, you know, I've been arrested, whereas if you put it in paper and it's not said in a courtroom full of people, you're more likely to get honest answers. What I would propose to the court now is I have a preliminary new questionnaire drafted that is shorter and able to be answered within a sufficient amount of time. So on Wednesday morning, I think the prospective jurors could be given this questionnaire, they could answer it. I think it would take at most 30 minutes for them to answer these questions, and then give the parties an hour, maybe 2 hours to go over it, and that would give the parties an opportunity to object to certain jurors for cause, have them approach the bench instead of having to do it in front of everyone else, and I think that would save sufficient amount of time and get the best prospective jurors in this case.
Has the state senior proposed shortened questionnaire yet?
No, I was working as of this morning.
Okay. Well, General, do you object to a shorter questionnaire?
I do, Judge. I would ask, first of all, how much shorter, but still, if you think logistically about how that would work. We did the numbers for the 11-page. If you have 75 or 85 prospective jurors, you give them an 11-page, 10-page, because it's actually 10 pages of questions. That's 750 or 850 pages that we would be asked to go through and try to pick out what's significant. Honestly, I don't even know if the state would really be interested in doing it, because you couldn't, logistically, you can't do that. I mean, you can't go through 850 or 750 pages of questions in a reasonable amount of time. And to the court's point, which the state has responded to this in writing, these are hours that we're talking about where we could simply be asking the jurors to, by show of hand, you know, has anyone served in the military? Raise your hand. And then Mr. Weiss can certainly go here on that question. It seems like, which way do you want to do it? You want to ask the questions, or do you want to make them write it down? I also do believe that there's a confidentiality issue where a lot of jurors would actually prefer not to write something down, not to put something in the record, but potentially be able to approach the bench like we offer them the ability to do if something is confidential. Maybe you wouldn't want to write it down, not to mention that we object to several of these questions anyways. But I think at this point, Mr. Weiss started with saying we originally had said we would send these out when the jurors are summoned, but we didn't. Well, I mean, it's not the state that did, and the state didn't ask for the questionnaire. This could have and should have been done earlier so that they could have been sent out, and maybe even follow-ups with jurors accomplished so that we had these back, or at least the majority of them back. It just wasn't done until 2 weeks before we're supposed to be going to Nashville. So we would object, but of course, this is within the court's discretion because it's a trial. So
I've never heard of any litigant, I've never heard from any judge that a questionnaire had ever been a waste of time. Every CLE, every court that I know that have used these questionnaires have found them enormously helpful. I have my questionnaires now down from 11 pages to 4, so that should eliminate 75% of the amount of material that I have to go over. In response to General Wamp's, you know, maybe people are concerned about the confidentiality. They can simply write down on a piece of paper, I would like to approach the bench about this, and I have to answer it on paper. That's perfectly acceptable too. But
I think the way these are, the questions are usually done is that there's an extra day. I know for the death penalty case, we bring in the jurors for an extra day. They fill out the questionnaires. They get exposed to the case a little bit at that point, and then they get. So in this particular case, in an effort to see if we can pull it off, I called the clerk, and there would have been difficulty getting this questionnaire to them without reading them in for an extra day. And so I think it would have been really difficult to pull off, even if we did it earlier, unless without scheduling another day. I think where we are right now is that it's either going to be a questionnaire that they can do, clearly can do within 30 minutes, and that might be helpful to the parties, or we just don't do it at all. I'd like to see the questionnaire myself.
I can have that submitted, I can do it formally through an email if the first,
Sure.
have it out tomorrow. Or I have it sent tomorrow.
That's fine, let's do that.
Okay.
But in any event, the parties need to be ready to be at the Davidson County Courthouse at 9 a.m. Central Time to do voir dire, whether it's to introduce them to the parties and hand out this very brief questionnaire or to start flight.
Yes, sir.
Okay? So that'll be taken under advisement.
There were, one of the motions that Mr. Weiss filed had to do with the defendant's rights under the Fifth Amendment to not testify. Of course, Your Honor, the state would always comply with that. The state agrees that the state cannot mention anything that would involve the defendant's Fifth Amendment rights. So that's an easy one we can agree to. I believe there were a couple others like that. Mr. Weiss, you might want to bring them up.
On that particular motion, but the motion will need to exclude the reference to defendant's silence, that what we're talking about?
Yes.
And not only just as a right to not testify at trial, but pre-trial silence.
That's what I thought we were kind of getting into. I'm learning a little bit more about the evidence that you guys are aware of that I'm learning about. There was a video apparently of Mr. Chen at his parents' house, correct?
Yes, and I have that video ready to play.
And there was another video of him in jail clothes. Is that correct?
That's correct.
So my question, I was reading this, of course, this seems to imply something beyond the normal prohibition against the state commenting on defendant's silence. So I thought, is there a video where he's silent and the demeanor is somehow relevant and that's what the state is trying to get at? Or is this just a standard motion not to comment on it? Okay, well, it's the same. Biography.
There was a motion regarding the state's use of Wi-Fi.
So apparently I'm the only one that can't access the Wi-Fi, so I will strike that motion.
Motion stricken.
Those may be the only ones parties have an agreement on, Your Honor. So at Mr. Weiss's pleasure, we can begin to go through the others.
The court appointed interpreter seems an easy one as well. I called the AOC, and I did contact you, I think, but AOC does not cover interpreters for victims or defendants' families at trial. So, did you want it at trial or just for the sentencing hearing?
Isn't sentencing part of the trial? In the case of an LWOP, life without parole, we're going to have a jury here, and I have witnesses that I call that don't speak English. I don't know how the court, if my client, or if the court does not appoint an interpreter in accordance with Rule 42, I'm going to have my client's brother translate for them, for the jury.
So, again, there's a difference in having the AOC pay for an interpreter that sits through the guilt or innocence phase and having an interpreter sit through the penalty phase. So I can tell you right now that the trial phase will not be covered. The sentencing might, but you're saying something different.
Let's make sure, because I'm not sure that we're clear. I am not asking for an interpreter to interpret the testimony that occurs during the trial to people, to my client's parents that are sitting in the gap. I'm asking for an interpreter if either of the defendant's parents were to testify at the sentencing.
So that makes more sense to me now. So the interpreter would simply be to interpret your client's parents' testimony so we can understand. Okay. Let me, I'll call the AOC on that specific issue, so I'll take that under advisement.
And according, I believe it's section 7 of Rule 42, says it is specifically paid by the state if it is during the course of a trial. And I would say that the sentencing phase is the course of the trial and so on.
So I'll bring that up if they say no. Okay, thank you, Mr. Ward.
Let's see what else. I don't want to, I'm walking back here because I don't want to move my laptop because it's all set up to play. The next motion is defense law motions that Jasmine Pace not be referred to as a victim throughout the course of proceedings and throughout the trial, and that she be referred to either by name or by proceedings. The state has produced case law that is basically judicial discretion. There's 2 or 3 cases I found on it where the Court of Criminal Appeals found the trial court did not abuse its discretion by refusing to refer to the decedent, or whatever you want to call it, as the victim. So there is nothing more than just asking this court as the gatekeeper in evidence to use your discretion. And we ask the court that Ms. Pace would be referred to as Jasmine Pace or the decedent.
This is, my understanding of the case law is that the problems come when there's a dispute on whether or not the victim was actually a victim, whether it's a self-defense case, whether it was simply an accident. I don't think the defense is arguing that a murder did not occur. So I do think that in this particular case, based on what the case law I've read indicates, the issue that prevents a person, or that should prevent a decedent being referred to as a victim, isn't present in this case. Does the state want to be heard on that? Or?
Your Honor, to the extent that the state would refer to Ms. Jasmine Pace as a victim, that's a theory of the state's case. We submit also that the jury would be instructed, following such comments, at the conclusion of all of the proof, before they are charged to begin deliberation, that comments and statements of counsel are not evidence, that they are the triers of fact, and that they are the ones to decide whether the defendant is guilty of the crime of murder.
Okay. All right. Anything else to add, Mr. Weiss, on this motion? Motion overruled.
The next motion was the law enforcement with Hamilton County and I believe it's the Nolensville Police Department executed a search warrant in 1942 Ashland Court in Nolensville, Tennessee. During the course of their search, they took pictures of, I believe it's the desk in the bedroom of Chen. And some of those have notes that we believe are protected by attorney-client privilege. And also, we also argue that they are not relevant under 403. And they don't have any probative value, and it's overly prejudicial. And I have those pictures ready to show the court.
State will be heard.
Your Honor, the state would submit that there are certainly portions of the photographs which will be shown here shortly. I also have them printed.
Oh, here.
Yes. Your Honor, I think by the agreement of the parties, we would submit photographs in question with the exception that the state has placed proposed redactions to material that we think would be objectionable, specifically, I guess, notes that you would describe as possibly statements about conversations with possible counsel, dollar amounts, it looks like. So we would submit this as a collective exhibit for the court's consideration.
I'll make that exhibit 1 for this hearing then.
And in light of the redactions, Your Honor, we would submit that it's not objectionable, it's not unfairly prejudicial.
Yes, sir.
I can provide these in digital format if the court finds it difficult to read.
You can refer to them if you've got a copy in front if you want. If you want to put them on the screen, just to make sure I'm looking at the same posted. You are certainly do that. On the defense laptop.
Yes, please. so this is the unredacted version, which is different than what the court has in front of it. Some of these notes have conversations or notes that we believe that the defendant has written and after having conversations with potential counsel, and we believe that's what all these notes are relevant to. So based on that, we would ask for all of the pictures of these notes to be excluded in total. If the court, otherwise, in the alternative, we'd ask the court to go through each note and choose which ones to redact if the court finds it in violation of Rule 403 or if it's protected by attorney-client privilege.
So, General, to understand you, the redacted aspects are aspects that the state agrees should be redacted, or?
Yes, Your Honor, and if we could, I guess, zoom in on, for instance, on, go to 276, Judge. Next one, one more. Yes, Judge, so if Your Honor were to draw your attention to the purple note towards the center of the screen.
Yes.
And Josh.
My copy is redacted.
Correct. And if Josh, what would you like to? Your Honor, it's got a phone number there. I recognize that to be a phone number of counsel. I don't know that it would necessarily mean anything to a layperson looking at the evidence, but in abundance of caution, the state did black that out because it is, I guess, indicative of somebody reaching out to an attorney.
I mean, if the state agrees that the blacked out portions should be redacted, we can just talk about the things that Mr. Weiss thinks should be redacted and the state doesn't. I guess we'll go through it post-it by post-it then.
Yes, sir. The first picture here is, I think, just showing all the notes, and then in the subsequent pictures, you can see individual notes.
Okay.
Here, the one that's labeled right hand, I don't know what relevancy this would have to the case. Obviously, it doesn't have attorney-client privilege information, but it's not
Relevance is a pretty low burden.
Just one more.
Okay. I mean, the simple fact that they're organized notes that has something to do with his life at the time, in context with these other notes. Apparently your client thought it was relevant. So again, 401 and 403 is a very low threshold.
Yes, sir. The note here on the, that's next to the purple note.
Hang on just a second. Is there a photo? All right, I'm looking at page 3 of exhibit lead investigator for the case?
Yes, sir.
Clearly, the lead investigator to the case has some relevance to this particular case. Overruled.
In this, I don't have the redacted copy in front of me, but in the upper left-hand corner, we're on the next page, Judge.
Okay.
It says, I need a legal, is this what redacted for? I need legal consultation, a potential suspect in this first case, and it says, I know I'm, let's see.
I got a pretty consistent I-N-N-O to be presumed says innocent, or would have said innocent, perhaps.
Asking for that to be.
What does invoke getting a lawyer in general? I mean, it's not, I suppose the analysis is whether or not it's privileged.
That is indeed the question, Your Honor. It reads more of a script of what he intends to tell somebody. It's not a privileged communication in and of itself. I would submit that on the note to the right, there is a name. It says Ben McGowan, which the state has agreed should be redacted. I think that's a misspelling of a local attorney here in Chattanooga, which, again, I don't know that jurors from outside of the county would have any inkling who a Ben McGowan is, but I would submit that the note on the left is extremely probative. It's not my lawyer told me 1, 2, 3, 4, 5. It is rather a script. It's a statement by a party opponent.
It seems to me that a fair interpretation of the note in the upper left, again for the record we're talking about, page 4, exhibit 1, the note in the upper left, seems to be a script of what Mr. Chen would have told his attorney. I think it's borderline. It probably does not qualify as a privileged communication because he's not saying that to his attorney. I think it's a fair interpretation of something he would have said to his attorney. I'm inclined to grant the suppression of that upper right, upper left, because it does seem to be pertinent to getting representation. I think that's a little too close for my comfort, so with that, let the defense motion to redact or suppress that particular upper left note on page 3 be sustained.
The next note directly below it, I believe, is a continuation of that same script.
I think that that's more arguable. I think that that's something that could have been written. It's less clear that that was written in preparation. I think the upper left note taken in context with the one in the upper right is clear. I think the lower left note perhaps taken in context, it might be a script that he was going to talk to his lawyer about, but since the upper left note will be kept from the jury, I don't think the lower for Exhibit 1 be overruled?
On the right side of the picture, the state has already agreed to redact the name of Ben McGowan. And the note below that, the yellow highlighted colors one, the state has redacted the 7,500, but below that, I think those are just statements, Paul. I don't know how those are running.
So, again, my copy is redacted. Ben McGowan. Top right. I'm looking for the lower right, but
This
7,500.
The state has redacted this part of it, but this part here is just a statement of law.
What do you think, gentlemen? That's something where I suppose the argument could be, he got that off the internet, but taken in context. It's
Sure, I
like,
think it also goes to guilty conscience, Your Honor.
go ahead, I'm sorry.
I'm not quite sure how that would show. I would need an explanation of how that would show a guilty conscience. And I can say those two things objectively, and that have no bearing or relevancy to this case.
I think a fair reading, it might have come from a conversation with an attorney who either been McGowan or attorney, doesn't seem like something that, I mean, that's correct, and it's out to hearing in 14 days. Perhaps that's something he could have gotten off the internet, but taking the context of the others, go ahead.
I would submit that he has not been arrested yet, Your Honor. So he's clearly contemplating that that is going to happen, that he has a guilty conscience, and obviously when taken in context with that note that Your Honor's ruling on it says that I think he's acknowledging how this is, that in fact, there is evidence that shows that he is guilty of crime and therefore will be arrested.
I don't know, it's just basically, this is a statement of law, like entitled to a hearing in 14 days. It's a preliminary hearing, police have to show probable cause, it doesn't seem more of a statement of fact. Any response to that? Other than what you already said?
No, Your Honor.
All right, the defense motion to suppress the lower right note on page 4, be sustained. Page 5.
This next picture is the posted note with the name Ben McGowan, but it's the full note. I think the court has noted that that's admissible for other reasons. And then here in the lower right-hand corner, you'll see another note that we've seen on the next photograph. It says, talk to her mom on the 26th. Premeditation, death threats, breaking and entering, and missing person yesterday.
I read that saying defamation.
It does say that.
Seems to me that's, again, speculative guess, but might be what negative aspects of his situation might be. He's getting defamed, getting death threats, perhaps. What do you think? That change your analysis where it says premeditation versus defamation?
Either way, I didn't think it was relevant.
General, what do you say?
Your Honor, I submit that for the same reason the court found statements about Saturday, November 19th, last time I saw her. Again, it's it's admission by party opponents. It also corroborates certain pieces of evidence. In this case, Your Honor may recall during the motion to suppress Officer Pierre's body cam video, where there's a telephone call between Ms. Jasmine Pace and this defendant. That this note right here, I talked to her mom on the 26th. That corroborates that that was indeed his voice. So that makes it extremely relevant.
I agree with you with the top part of the sentence, I'm talking about the second part with the defamation, death threats.
Sure. Your Honor may also recall that there was testimony by Investigator Crawford that the defendant's cell phone placed him in the area after the search by the Pace family. That indicates and corroborates the fact that he was in fact there. If he did not return to his apartment, how would he have known of breaking and entering? Furthermore, Judge, one of the recordings that the state has in its possession, which the defense also has in its possession, is a phone call, again, recorded, where the defendant is complaining of people threatening him. So I would submit that on that, under 403, it's not unfairly prejudicial. This corroborates and identifies him in other pieces of evidence.
I think the top part of the note definitely comes in, but the second part seems that it might be something that his attorney instructed him to do, or talking to an attorney, I guess either Ben McGowan or someone else. I don't know if Mr. Chen would have gotten defamation, off the internet, but it seemed like something a lawyer might have told him. So let the defense motion to suppress the bottom half of the bottom right note on page 5 of Exhibit 1 be sustained.
You mean top right? I don't know how you're
Like this bottom right, the defamation. Oh, I was looking at page 5.
It's the same note that
Okay.
you're looking at, it's just a full map.
So I guess looking at page 6, yes, looking at page 6 of Exhibit 1, it would be the top right note. So let the first sentence should come in, talk to her mom on the 26th, but the line below, defamation, death threats, breaking, entering, the defense motion to suppress that one statement be sustained. And then I wasn't looking at this bottom line. It says missing person yesterday. Either side want to provide more information other than those 3 words.
That's all we got.
Never.
That seems to be less legal, coming from a lawyer, and more something he might have gotten from following the news. So the only thing that will be suppressed on that top right note will be the middle line, the middle entry of defamation, death threats, breaking, and entering.
The note below that, Your Honor, the state has agreed to redact the top portion of it where it says the deed, the phone number, and the address, and then the number of the circular in the middle. However, you can tell from the context of this note that this is a conversation with this attorney. Notes that are contained in are obviously notes from the conversation.
See if I can read it correctly. It says November 19, last time I saw her, she would call me. Last time was on, she would call me once a day. Last time was on November 22nd on phone. That seems more in line with the other notes that came from Mr. Chen that have already been ruled admissible. Seems more in that line, Mr. Wise. Anything else you want to say about that one that hasn't been said?
So, otherwise, the state's redaction is just an agreed upon, and the rest of it's listed. And then here's the last one. This is a note in a notebook. You can see the name at the top of Ben McGowan and his phone number.
This is page 7 of Exhibit 1. see, Friday, November 18th, last time I saw her, Tuesday, November 22nd, last time we talked. She has a huge history of running away from home in her teenage years. Mom was an alcoholic, ran away, let's say, to Canada for several years, and was homeless. Trying to see if anything under the stricken through language is legible, so if something has a restraining order against her ex. Her dad left when she was a kid, has a restraining order against, does that say me, or does that say? Ex, okay, ex. Says she was recently online on Facebook. Again, that seems more in line with Mr. Chen's recollections rather than
The state has
clearly.
redacted a portion at the top, so we obviously agree with that. We asked for a portion of redacted.
As with these other notes that have been brought to court's attention about Mr. Chen's interactions with the victim, it seems this falls in that same category to the defense motion to suppress the notebook entry on page 7 if it won't be overruled.
And then, Your Honor, there's, going back to like the first picture of it, there's a picture of all the notes. So I would ask that the portions the court has ordered to be redacted and the partially redacted by agreement of parties be redacted on all copies shown picture.
Okay.
Yes, Your Honor. I'll submit the proposed redactions this evening.
This motion also references a video. Oh, I'm sorry.
That motion references it.
I'm looking at the one with the search warrant. The style of motion looking to exclude defendant's statements and video. That's something different than,
Yes.
Okay.
That, so just to give the court some context, the defendant was arrested at his parents' residence in Owensville. There was one officer that had a body camera that captured it. It is not an official interrogation, I would say. However, there is no question that the defendant is in custody, which the state agrees with. The relevancy of playing this video, or there is no relevancy to playing this video. It's overly prejudicial. There's a waste of time, and I don't want the court to get into it in front of the jury. The video is about an hour long, but I believe it's only the first 20 minutes, 25 minutes. That is relevant.
gentlemen, before you play the video.
The state reserves argument.
Oh.
Recording. Are you going to recording? Yeah, that's what I'm saying. I want to make sure you all do.
only and vote.
Jason? Understand translation of that?
What language do you speak? Chinese, Mandarin? We have a search.
Search one of your residents?
Outside.
No. Like you come out, it's not like this.
You have my phone.
years from now.
Oh, so we are.
Oh, yes, yes.
Oh, okay. I think so.
No, I'm sorry. No, okay. No, that's fine. That's right. I'm sure he's not.
I'll explain. We're going sort of Chattanooga system.
All right, you're gonna go with this officer right here. We're gonna patch down, make sure you have anything on you. This is you in the back of the police car. I appreciate it.
You're not gonna change it to this time real quick, okay? You said you want to talk to Woodard, or something like that, okay? There's the meantime, I had to change it to the police department. So, in the meantime, we're not gonna make them wait in the rain. Is there, my understanding, we have family members on around here?
Yeah.
Is that correct?
Yeah.
Is it across the street?
Yeah.
Okay, it'd be okay with us, if I could get phone numbers for them, contact numbers, and I would have to issue them over there, so that I can wait my phone and stuff. And then a copy of the search warrant, we'll coordinate with them.
So why would I need to be put in the police car?
Because you can't go down there. You're not free to go down there by yourself. You're gonna have to go down there with us.
So
We also have a search warrant for your person.
for one person?
Correct.
Okay.
So there'll be some processing in there. Okay. So that's the reason why, and if for anything else, we can do that.
Correct.
And it just speeds the process up and people aren't standing around.
Okay.
Okay.
No. You're not.
Okay. I'll answer whatever questions I can. Do you have questions for us?
What I hear on goes to Jasmine. You try you, but you built the cannon. Yeah, me la chupó, no,
Then it went on to work to my.
Did she grab it first?
Where is her first?
Yeah, I mean, to my father now.
Just get your room.
Is there a room?
What's the first look like?
Yeah, my father, no one is. Yeah, no one is. any idea? We can get an order. It's upstairs in the last, on the bottom door.
That's right.
And they got me chopping on. She walk over with you. Is there any animals in the house? We left the door that's like locked. Do we need to open that door?
So you're okay with going back to ours? Yeah, you want to go ahead and go back right now?
Yeah, that's.
Okay, all right. He's gonna pat you down, he's gonna place you in handcuffs, not place you in arrest, you just call us and you go to the back of the car, so you have to put the handcuffs, go.
Okay. So you said there was a search warrant for me?
Correct. Yeah, there's a search warrant for your person, so we're, Knoxville Police Department, we're gonna be detaining you in compliance with that search warrant. We're assisting Chattanooga.
Okay. And, is there any like probable cause or anything?
They'll explain that, they're gonna explain that to you, that's a big one, yeah.
Okay.
We're gonna let them do that, but I don't wanna speak for them. Yeah, we don't wanna let you know. Misinform you of anything, so they'll tell you all that when we get down there, so just take it from them. They're the lead on this, you don't wanna know from us, so.
Yeah, we know it's legitimate. We wouldn't be enforcing it if we didn't think it was, we didn't know it was. But we'll let them explain it because we don't want to pile on information. We'll let them one time it only, you know?
Okay.
All right, so if you will, just face away from me. All right, do you have anything on your person? Drugs, weapons? I go to the chance, by the way.
I just moved everything around that I had done. My hands all coordinated, yeah. I lost my good key. Hey, sorry. You good with him waiting here until? Yeah. Okay. Double out and check for tightness. You good? So, they feel all right? All right. You're right, all right.
Yeah, that's me. Okay. We're gonna go to the opposite side, back door. Oops, sorry, I stepped over that. We'll go through the grass. Then we'll go to the far door. Like would be a diagonal from me.
That's pretty much the entire interaction, Your Honor. Everything else is him just being transported. I would move to enter this as exhibit number 2 for this hearing. I have a flash drive and I'll provide it to this witness.
Okay, exhibit 2.
Your Honor, this video should not be admissible at trial for a variety of reasons, as I've stated in my motion. It shows the defendant in a state of undress. There is no Miranda warnings. It's questionable whether or not these are voluntary statements that law enforcement is using my client as a translator to communicate to my client's parents that they have search warrant and they're coming in because of those issues. And then Mr. Chen here is trying to understand why it is that he's being taken. There is a search warrant, but there's no arrest warrant. So there is some confusion of whether or not he has to go with police or not. So just trying to understand it. But the most important thing is the placing of handcuffs, the executing the search warrant, in no way makes any other issue or fact in this case more relevant. The probative value here is substantially outweighed by the unfair prejudice, especially with showing the defendant being placed in handcuffs. I just don't know what the purpose of making this a trial would.
John, I have a few concerns about this one. It seems like there is a legal discussion going on where Mr. Chen asks about probable cause. He wants details about it. The fact that he is speaking in Mandarin to his parents. I'm a little concerned if, I don't know what that translates into, and there may be a juror who thinks they might know a little Mandarin enough to maybe make a mistaken interpretation of what was going on. So I've got a few concerns about this video, but I'd like to hear your thoughts on it.
Sure, Your Honor. Let's start with the constitutional challenge raised by the defense under Miranda. Miranda applies to custodial interrogations, which creates a two-part analysis that the court has to look at. First, was the defendant in custody? And secondly, were the statements the result of an interrogation? I think that the court candidly can take notice of the fact that a reasonable person being placed in a police car, being told they can't leave, that they're being handcuffed, would create a custodial situation. The question is whether or not the statements that were made by Mr. Chen were the result of an interrogation by law enforcement. The law on that's fairly clear. It's questioning or statements, words, actions on the part of the police, not the defendant, the police, and not the defendant's family either, that would reasonably elicit incriminating information. The defendant hasn't made a challenge to the content of the statements to his parents. Obviously, the defendant is in a far better position to understand what is being said between him and his parents and to lodge an objection to whatever that is. I understand the court's concerned that there might be individuals who speak Mandarin on a jury.
Let's say I agree with you on the custodial aspect of it. Let's look at the relevance argument on that. The danger of unfair prejudice is what I'm looking at this, which might substantially outweigh any probative value. I see very little probative value, and I see, you can please let me know what I'm missing. I think there is some more there. I do think there is a potential danger of substantial unfair prejudice with the defendant discussing legal terms. Like, how's the jury going to take that? Are they going to think he's a pre-law major? Are they going to think that he's been educated about this in the last week? The fact that unless we get a translator to what it said, what was said between Mr. Chen and his parents, that's basically sending testimony or statements from the defendant to the jury that we're not going to know what they were. So, you know, as far as relevance and the danger of unfair prejudice, I'd like to hear your thoughts on that.
Yes, Your Honor. I would submit that there's actually two separate inquiries that the court needs to look at: the relevance of statements, the audio portion, and then the video portion. But first and foremost, the state would submit that this video is relevant for several reasons. First off, it places the defendant in the place to be searched, the Nolensville address attached to the report. He's also wearing a very distinctive hat. Your Honor can see that in the video. It's red and white. That will come into play throughout numerous pieces of evidence that will be introduced during the course of this trial. In essence, it's a form of identification. Also, the defendant's demeanor is relevant to the trier of fact in this case. So I would submit to the court that the video itself is relevant. The question then is, well, is the audio more relevant than the video? I would submit that if the court is inclined to grant the defendant's motion, that the court also needs to look at whether or not a video of a defendant wearing a particular article of clothing, which the state would proffer to the court, will be seen throughout numerous other video recordings of different locations on different days. That is highly relevant, highly probative. And 403, Judge, is really a law, a rule, if you will, favoring the admissibility of evidence. In fact, excluding relevant evidence under 403 is an extraordinary remedy that should be used sparingly, and that persons seeking to exclude otherwise admissible relevant evidence have a very significant burden of persuasion for Your Honor. The defendant in his motion says that it's marginally, of his words, marginally probative. The state would submit that it's significantly probative. But in light of that, Your Honor, the question is, the burden is on the defendant to demonstrate that the defendant's video recorded statement captured during the initial interaction between law enforcement and him at his residence in Nolensville creates a prejudice that substantially outweighs the probative value of that video recording. So I would submit that on that basis, Judge, you have to look at it both for the entirety of the video, including the visual portions, but also the court is very well aware that audio can be redacted from video recordings, and sometimes that is what the court rules.
What probative value would be lost if a still from the video showing Mr. Chen at the door of the Nolensville address while he's wearing his red hat, if that were to be considered? What does the state lose from losing audio and video if that were to be considered?
The defendant's demeanor, the clarity of his face. Your Honor can see the lighting is very poor, so we'd be picking, in essence, having to choose between a very distant shot of the defendant descending the stairs or in close proximity to the staircase where it's not clear, or a much clearer image of the defendant's face, but it's under the, I guess, the entryway of the house where it's very poorly lit. You can see his face much clearer, but you can't see the hat very clearly. So in essence, it would be forcing the state to choose between two not so great options.
So, again, can you tell me why his demeanor is relevant in this particular case? I mean, would it be more relevant if he was, or less relevant if he was excited, less relevant if he was more subdued? What relevance does the demeanor in the video have to
Courts
gain back the
recognize that
confidence?
coolness of fact after a violent homicide is evidence of premeditation. Being confronted by law enforcement officers with a search warrant for his residence, Your Honor has seen it, he's calm, he's collected, he's not at all worried, not concerned to any degree other than, do you have probable cause? Security serious questions for somebody who professes his innocence and is right.
Want to be hard on that?
Yes, Your Honor. I believe there is a picture, I'm trying to find it now, that Nolensville Police Department took of Jason Chen when he was detained, and I believe that he is wearing that red hat, in fact. Listen. We're going to show it to the court. So the state needs to be able to show this hat because it's important to their case. They have this picture, which should suffice just the same. This picture is better than any still that you can get from that video.
And so I'm clear, is that the picture that was taken when he was taken to the Nolensville Police Department?
Yes, sir.
From the house?
Yes, sir. So they have a picture of the hat. That can't be an issue. The video needs to be included with that. And then, most importantly, my belief is the state wants to introduce this because they want the jury to see the defendant arrested, placed in handcuffs, and transported to, eventually to the jail. Because what does that give the impression of? It gives the impression of guilt. Watching someone get arrested and be placed in the back of a cop car gives the jury the impression of guilt. That's why it's an unfair prejudice. There was nothing said, at least nothing today, that was incriminating whatsoever. There is no probative value to that video whatsoever. The only thing that the state has drawn upon is the marginal probative value of his demeanor. And I think the court kind of hit it right on the head. What if he was excited? What if he was scared? What if he was calm? No matter what his demeanor is, that would make the video admissible. Because he's calm, 6 days after the alleged killing of Jasmine Pace, I mean, it's been 6 days since that point. So what type of demeanor is he supposed to have? So I don't know where the probative value comes in, even if it is, it's marginal, but the unfair prejudice, this is what the Rule 403 was made for, was to exclude videos like this.
What I'd like to do, I do think that there is danger of unfair prejudice in that video. What I'd like to do, General, is if you could provide a 30-second clip of what you think captures a demeanor interaction with the red hat. Obviously in the place to be searched. And I think that's pretty much as far as I'm comfortable going with this video. I do think there's a danger of a substantial danger of unfair prejudice for some of this video. That doesn't mean the whole thing needs to get excluded. So if you could develop maybe a 30-second clip that covers that, and I could review it and then make a ruling on that later.
Yes, Your Honor.
I'll take that
I'll
under advisement.
do that this evening.
I'll take that under advisement.
Moving on. The next motion involves the, I don't know if the nomenclature is going to be correct, but the message that was sent allegedly from Jasmine Pace's phone to Katrina Pace's phone containing a address or location influence. We had previously litigated that issue. I can provide an exhibit, but if the court wants to take judicial notice, this is the same picture that is presented in the motion to suppress evidence. The state has provided the defense two photographs of a phone showing a pinned location. The defense has never been provided anything other than that. So in these situations, I would have expected the state to have done an extraction of the phone and provided digital forensic evidence demonstrating that Katrina Pace actually received this message, where it was received from, and when it was received, how it
was received, all those things. I've received no information that verifies that a pinged message, even from the service provider, that went from the Jasmine Pace's phone to Katrina Pace's phone. And in addition to that, we're alleging that it's hearsay. We're alleging that it can't be authenticated. We're saying that it's not the best evidence. And for those reasons, that these messages should not be admissible unless the state does the things necessary to properly exclude for hearsay, authenticate it, and provide it to defense counsel.
Well, I mean, I guess this would be it's kind of a pre-trial ruling on something that the state could clean up, perhaps between now and trial. I know that some video and text evidence can be authenticated without having the person from T-Mobile or Facebook or wherever to be here. So I think that it's possibly something the state could do. I don't know if that's something they want us to do. General, I mean, are you planning on using this for anything other than a non-hearsay purpose?
No, Your Honor, and the state did respond to the defendant's motion in limine on this issue. We don't believe that it's hearsay for multiple reasons. The first and foremost being that it is the best example I can think of effect on the listener. The reason why the state has already introduced this evidence, at least once, if not more than once, is because Jasmine's family was looking for her. They did not know where she had been killed until they realized she had dropped her pin. That is what led them to go to Mr. Chen's apartment building. If you don't introduce this to the jury, there's this hole of the jury wondering, well, wait a second, they're looking all around town for Jasmine, trying to figure out where she is, how her vehicle got from here to here, where her vehicle was in this weird location where they believed it was, and then all of a sudden they are knocking on Jason Chen's door. The effect this had on Katrina Pace is why it's being introduced.
And again, I think what I'm reading here, there's two different arguments from sides. Where the defense is saying that it should not be admitted for the truth of the matter certain, but the state's saying it's not being admitted for the truth of the matter certain.
It is not.
Okay. Why do you have a response to the non-hearsay objection?
So let's make sure that it is a hearsay statement. You have to understand that there is a message from, allegedly, from Katrina Pace, from Jasmine Pace to Katrina Pace. That message in and of itself is a communication. It is a statement by an out-of-court defendant. So,
Depends on how it's used. I mean,
but so if Jasmine Pace did send a message, and it was communicated, so that does make it hearsay. And then the information contained in it is being used for a non-hearsay. I don't understand how it would be used for a non-hearsay purpose. The purpose is to communicate my location. That's why you send a thing, is to communicate this is where I am now. So I don't understand how that is to prove this is where I am. So what other purpose would it be?
Well, you can argue that a limiting instruction to the jury that it's not to be used for the truth of the matter asserted would not be sufficient. What the general has argued is a pretty clear and I think common non-hearsay purpose. If someone says, I think the guy who did it ran in the house, that can be used to explain why the police went to a particular house. It doesn't mean that the guy who did it ran to the house, but explains why the police went there. And so it seems like this is pretty much along the same vein of explaining why something was done. As long as the jury gets a limiting instruction that's not to be used for the truth of the matter asserted, but only to explain why, in this case, the Pace family went to Tremont, that seems pretty textbook, not what you're saying.
For only the hearsay issue, not the rest of the issues that cited in the motion.
So I'm going to say it to you the way that I understand it. Please correct me if I'm wrong, gentlemen. The state's not going to say, Jasmine Pace sent this text to her mother and it clearly establishes she was at Tremont at that time. They're not going to say that. The argument is going to be, they were at, I believe, at a Waffle House, perhaps, if I remember correctly. They saw a text on her phone and a pin drop from this location that explains why they went to Tremont. And that's it.
And the court would give a limiting instruction on hearsay.
Yes, sir.
I understand that.
Okay, so anything else that needs to be said on this that hasn't been said yet?
Well, I would like to go ahead and address authentication, Your Honor. The state doesn't see this as that complex of an issue, especially when you consider Rule 901 and the law that's attached. And again, this is sort of spelled out, but I think in these courts and in courts across the state, it is often, and I cited cases that are directly on point, we often use pictures of someone's phone or screenshots from someone's phone as evidence. The example I gave in the response is that if someone takes a screenshot from Instagram of a person holding a gun, well, we don't exclude that because we don't pull the phone up and put it on the projector in front of the jury. We accept after it's authenticated, so we have to have someone on the stand that can say, this person is so-and-so, so-and-so, this was the Instagram account that was associated with him. We are going to have a witness who had her daughter's cell phone number in her phone. She had her named as her daughter, Jasmine, which is what she called her. She is going to testify that in her phone, in that text conversation, that it was not a text message, it was a shared location. She may or may not actually be able to pull it up, but that's not the standard here. The standard is that she pulled it up for law enforcement officers. Photos were taken of what she pulled up on her phone, and those photos have been given to Mr. Weiss. They will be properly authenticated. I understand that they're not. Certainly there can be an objection, but this is standard in the course of evidence introduced to juries, is that she pulls it up, the photo is taken. It is the best evidence. It is the photo that was taken of her phone. We don't ask witnesses to take their phone out of their pocket in trial. We certainly don't turn over a witness's phone to the defendant, as has previously been requested in this case. It's just not how, frankly, it's just not how it works. And so this is evidence, it is relevant.
I think I agree that
Okay.
for the authentication purpose of the non-hearsay, all you need is Trina Pace to say, yes, this is what I saw that led me to go to Tremont. I think Mr. Weiss's argument would be, I think better placed if the state's trying to say, this is from Jasmine Pace, and it shows that she was at Tremont, then there would need to be another level of authentication to show
Yes,
that but that's not what the state's
That is not. The line of questioning is exactly what the court assumed, which would just be, was there, Ms. Pace, something that led you to want to in Tremont? What was that? Simply. That is, in fact, the reason. It is not for the truth that matters, sir.
Based on what based on what the parties have argued that this evidence will be used for a trial, which is a non-hearsay purpose, I do believe that the evidence can be authenticated through Trina Pace. So therefore, the defense motion to exclude the text message for the non-hearsay purpose be overruled. Mr. Weiss, if for whatever reason during the trial starts getting spun in a way that it's argued for the truth of the matter, sir, you can certainly renew your objection to that.
And just for the purpose of the record time, Judge, if you would reference whether or not this message would be excluded according to the rule 1002, this is not, it's obviously not the breach of law. And the court, it's not a rule of exclusion, which is true, but it is not the best evidence. And the best evidence in this case would be forensic data of that text message approach, proving and verifying that that message was sent. And without providing the best evidence, without providing the original evidence, it puts that the forensics in this case in doubt.
For the non-hearsay purpose, that the state's offering for the best evidence would be the actual cell phone. You don't need any type of official report from any company for what the state is using it for. All you have to have is Ms. Katrina Pace say, I looked at this text and it caused me to take my family to Tremont.
No,
So
that's for the 901, that's the authenticator. here, I'm saying that it's not the best interest. Now, if
The best evidence is the original, correct?
I mean, it's
The evidence means
the
it's,
phone itself.
right.
By not providing the best evidence in this case, it puts the defense at a disadvantage.
Okay, for the non-hearsay purpose of Ms. Pace saying, I saw this text, it was pin drop, and I decided to go to Tremont, how is not having the best evidence detrimental, unfairly prejudicial to your case?
Well, so that's more of a rule for, that's a relevance over the prejudicial 403 issue, which I would also contend with, but for the best evidence, it's being able to show, I received this message, here's the phone, it came from my daughter's phone, here's the proof of it.
You see, there's a distinction with what we just said. Say it came from my daughter's phone. The state's not going to say that. The state's going to say, I think it came from my daughter's phone. It came from a number listed as Jasmine's. And so that's why we went there.
But the best evidence to prove that comes from the phone, not a picture of the phone or a person's statement.
I do believe that the best evidence allows for duplicates to be used in place of the original, where the original perhaps isn't available. In this case, we're talking the difference between not a duplicate of a document, but a picture versus the actual phone. And I think for the purposes that the state is saying they're going to use it for, I don't think that the best evidence applies for this particular purpose. So let the defense motion for under the best evidence rule for this particular issue for the non-hearsay purpose be overruled.
I assume that would be the same ruling for the relevancy part of the motion.
Yes, it's relevant in the sense that it explains why the Paces went to Tremont at the time they did. That's obviously has a tendency to make the existence of a consequential fact more probable than without evidence. Next.
Two more, Your Honor.
Okay, you want to take up first?
Your Honor, we're going to take up the motion related to the photographs.
Got three more, by the way. Got the photographs of the decedent, video dressed in jail attire, and there's a demonstrative evidence one as well.
Yes, we'll do the demonstrative after. I believe that the demonstrative are included in the photograph that we referenced in the first motion, so it might be moved in the other rule.
Your Honor, obviously, this is sensitive content for everybody in the courtroom. We have let the victim's sister know. I think she's been saying here, but for everyone, this is the first time that this has been shown, and it is very sensitive.
Well, we could do this if you, I need to see the photos.
Sure.
If you want to just submit them to me, no?
I'd like to do it today.
Okay. All right, we're about to show some very graphic material. This is something that can be very emotional. It's relevant, it's important to have the emotional aspect of this discussed before the jury sees it. So we're going to put some very graphic photos on the screen. Do we have to do the screen? Can you just not hand it to me?
I have, the state has printed out copies, Your Honor, and I also have it on a flash drive. I can go through the numbers of the issues.
Do you have hard copies of all the ones that, it might be easier, does the state have hard copies of the ones you intend to use?
Yes, Your Honor.
Okay, let's do that.
Your Honor, so, what we have is the state has
Yes.
the state has limited the amount of photographs that they intend to use that have been provided from the medical examiner's office originally. You'll see on the bottom of the page, Your Honor, that there's numbers that start with 216 and that go through 254. Those are the numbers that correspond with the evidence that the state has provided to us. So for the ease of everyone involved, I'm going to reference those numbers starting with 216 and going forward.
Let's go make this exhibit 3.
Thank you, Your Honor.
All right, gentlemen, we can do this a couple ways. I know you're objecting to it, but it might be easier for the state to say why they think it's relevant, or, you can argue that it's not relevant. They're going to just turn around and argue why it is. might be easier, even through a motion, to have them explain the relevance.
Well, I think that there's a few things, Your Honor, that the court needs to consider, and there's specific pictures that I would like to direct the court's attention to. Starting with 216 and going forward. These are x-rays, as the court can see, that contain images of Miss Pace within the suitcase. I would direct the court to image 220. That would be the fourth page in Exhibit 3.
Okay.
The court should note that in that picture, the bottom there is a signature for A. Smith. The defense's position would be, Your Honor, that this photograph is not a photograph that was actually taken by the medical examiner's office. We have combed through all of the pictures that were originally received from the medical examiner's office, and it's the defense's position that this is a combination of a number of different angles of the suitcase that has been combined to make one photo. You can see in that photograph that there is coloration that is different from the rest of the black and white photo. That would lead the eye to see certain objects, including the handcuffs and restraints in the suitcase. With that being said, this does play into the demonstrative evidence that we are objecting to coming in, but our position is that while there is no question that the state is going to allege that Ms. Pace is found in a suitcase, this evidence creates evidence that doesn't exist. There was no x-ray, there was no photograph of the suitcase as a whole, there was no photograph that was presented to us that shows the handcuffs in the position that they are. In fact, if the court actually examines that photograph carefully, you can see another set of metal that's not colored, and it's confusing for the jury. So our position is that 220 should be eliminated as it is unfairly prejudicial to Mr. Chen.
What part of 220 is colored that's not about the shoulder area? Or
When you go through, Your Honor, there are on my copy there are blue pictures, and that does not exist in any photos that have been actually provided by the MD's office. You'll see at the bottom, this is the only photograph in the series of 216 through 220 that contains A. Smith. She is an employee of the medical examiner's office. She has created at least 2 demonstrative exhibits that have been provided to the defense. That coloration, that blue, is just to accent the metallic portions that don't exist in the other photos.
are you talking about the blue around the handcuff, or the blue, the little triangle shaped blue kind of the bottom?
Both.
But bottom one. Okay. Well, is this a conglomeration of photos that were taken by the medical examiner's office?
You can see that they are obviously spliced together.
I do. I see that, but I mean,
We have not, I'm sure we could take the pictures that have been provided by the MD's office and have something close to this, but we don't, there's no way for us to really authenticate where this photograph comes from. We weren't provided a copy of this actual photograph or anything similar to showing the entire body within the suitcase as a whole. And what we have are individual pieces sectioned off in multiple photos.
I mean, we'll say a badly decomposed body was found in the woods with the bones scattered, and there are photos of the bones in the places where they were found. But then people found them, kind of put them together in the woods to kind of show that it was what they could, and that was a legitimate photo, not of what it was as when it was originally taken, because the bones were scattered, but they, with the understanding and the explanation to the jury that these were put together to kind of give a more cohesive picture of what was found. You know, why wouldn't a similar explanation remove any danger of unfair prejudice in this particular photo?
We don't have body parts that are scattered in this. We have a body that's in one location. The MD's office was able to scan portions of this. They had the ability to take pictures of the entire suitcase and to scan the entire suitcase. They chose not to. What they did do was take pictures to build something that they had the ability to do it at the beginning. If, in your situation, if the bones were built, the MD's examiner or investigator would be taking those pictures and presenting it to the state and then to the defense. This is not something that we received until a month ago, and this is evidence that obviously has been pieced together for the purposes of demonstrative issue, and our position is that it is prejudicial. Dr. Coxwell will have the ability to talk about the condition of the body. They'll have the ability to show Ms. Pace in the suitcase, potentially, if the court rules that those pictures come in. But he'll be able to talk about that. This evidence is truly created. It wasn't existent or in existence. It was not made at the time of the discovery of this case, and it wasn't created at the time of the investigation. It has been created by someone within that office much later in time.
Well, again, I understand that the bones weren't scattered in this particular case, but it seems like this would come in through an expert, and experts typically delve through reams of data that seems spread out and unconnected, that they can put together a report or a diagram or something that kind of draws it all together. Does the fact that this photo, or this conglomeration photo that's 220 here, be presented by an expert? How does that factor your argument?
Your Honor, I believe that Dr. Coxwell will have the ability to testify about the condition that Ms. Pace has found and the steps that he took to find it. Our position with this specific photo is that there is no question that this photo does not exist and that it has been pieced together by multiple other photos. If you go through 216, 217, 218, 219, you will see portions of these photos that likely created 220. Our position is that at this point, 220 is going to be cumulative of 216 through 219. But furthermore, it's going to be prejudicial because it is showing evidence that they have created truly for demonstrative purposes, that they're trying to have issued as the proof for the jury to consider as what they see. Dr. Coxwell can testify to what he's seen, but this picture doesn't clearly show the jury what Dr. Coxwell saw. It does not show what the investigators captured when they were taking the many photographs they took. And there are hundreds of photographs, Your Honor. There's nothing that looks like this and what we've ever seen.
General?
Your Honor, 216, 217, 218, and 219 are X-ray images. They're not photographs. Let's start with that fact. I believe that Dr. Coxwell, during his testimony, if asked, would say that the X-ray machine would not be able to produce an image of the entirety of the suitcase in a single scan, if you will. Court is 100% correct. Image 220 is a demonstrative aid. It is a conglomeration of 216, 217, 218, and 219 to show them in correlation and context with each other. There would be nothing preventing the state during direct examination of Dr. Coxwell or an argument from putting photograph 216, 217, 218, 219 next to each other, piecing them together, and then highlighting for the jurors the various important metallic objects that are relevant to this case. Not the screws in the suitcase, not the handle, but the two sets of handcuffs, what are described as handcuffs and shackles. And then Your Honor mentioned the bluish object in the bottom right corner. That's the knife blade that was broke off of Jasmine Pace's body. That's clearly relevant. It assists the trier of fact in understanding the positioning of Miss Jasmine Pace, because candidly, Judge, the proof will be that there's this suitcase. Your Honor will get to see it. The jury will likely get to see it. And an incredulous juror might say, how on earth does a human being fit into a suitcase like that? This photograph, 220, the composite X-ray is what I would call it, shows exactly how Miss Jasmine Pace was positioned inside the suitcase, shackled with a knife blade broke off in her chest. That, Your Honor, it's not unfairly prejudicial. Is it prejudicial? Of course, because it's evidence of guilt. It's evidence of a murder. The question is it unfairly prejudicial? And the defense has not met their burden.
Ms. Morrison, I'm sorry, go ahead.
If I may briefly, 216, which is the first photo, that also shows that same knife tip. The state is asking the court to have the ability to enter pictures showing the same thing multiple times. Our position is 220. It's a combination of 216, 217, 218, 219. If they want to stand up and highlight the fact of the jury, that's one thing. But they've created a photograph that they intend to have the jury see as something that's brought from the medical examiner's office. That does not exist. If they want to, as Mr. Moreland said, stand up, highlight for Dr. Coxwell and show the jury the pictures, if the court says that they come in, they have the ability to do that. 220 is created to give the jury the illusion that this is what the AD's office saw, and they did not. They did not see bright blue metal pieces showing up on their x-ray, because 216, 217, 218, and 219 shows what the AD's office saw. I know that, the fact that it's colored blue may sound trivial, but they are highlighting something, creating a picture that is brought to the jury's attention, asking for the jury to accept it as proof of what the AD's office saw. And we're asking for the court to find that it is prejudicial. And there are other photographs that the court will likely allow for them to have in, including 216 through 219, that shows the exact same evidence.
I find that since this is coming in through an expert, that an expert certainly can put together images or data in this particular case. It doesn't even seem like he's putting it together himself. He's just explaining the suitcase that he saw and how the x-ray machine was not able to take one x-ray, everything. I don't think that, while it is prejudicial, the test is whether or not the danger of unfair prejudice substantially outweighs the probative value. In this particular case, since it's coming from an expert who can explain that to the jury, I don't think that danger of unfair prejudice substantially outweighs the probative value in photograph 220 of Exhibit 3. So the defense motion to suppress photograph 220 be overruled.
Your Honor, in starting with 221, part of our motion, and going through 254, just so we're clear,
Okay.
Part of our motion does request that the state's photographs be in black and white that display the victim. I won't go through each photograph for 221 through 254 and request that the court look at that photograph specifically and make that ruling, but we are asking that any photographs of Ms. Pace be in black and white for purposes of discoloration for blood, organs that are showing, and so the state may want to respond to that, and then we'll go through what we believe are the cumulative photos.
General?
Your Honor, the case relied upon by the defense in this case the proposition that color photographs should be excluded is extremely distinguishable. They rely on a Collins opinion, which is out of Hamilton County, Your Honor, quite a while back. In that case, the jury was shown color photographs of, quote, a bruised, bloodied, nude infant victim. And that's at 986 Southwest 2nd, 13, but specifically at page 21. You might be inclined from hearing that description of the photograph provided for the jury's consideration in that case that it was a traumatic cause of death. Maybe beating, stabbing, gunshot wound. Rather, the cause of death in that case was drowning. Which raises the question, what would be the purpose of showing a bruised, bloodied, nude infant? In fact, the medical examiner, when asked by the trial court to explain the photograph, said the pictures would show what the baby looked like, the size, but there's nothing really in the external exam of the infant that I think is confusing. Those are photographs of the infant in that case. In fact, the Collins opinion cites a different set of facts using an infant which showed color internal organs. The Court of Appeals in that case said that those were appropriate because it went directly to the heart of the question of what was the cause of death in that prior case, and in that prior opinion, the cause of death was massive internal hemorrhaging and bleeding. I would submit to the court that the color photographs in this case are extremely important. Dr. Cogswell will testify, I anticipate during the course of his direct examination, that he is able, based upon his examination of some of the wounds, to be able to opine as to the amount of blood in Miss Jasmine Pace's vasculature, her circulatory system, at the time that the stab, incise wounds, slashing wounds, so on and so forth occurred. Your Honor will look at some of the photographs, and let me just draw your attention to a couple of them by number specifically. If you look at photograph 241, 241 shows Jasmine Pace on the autopsy table with numerous marks. Your Honor will note that some of the wounds are more red, some of them are more yellow. There are close-ups of individual wounds. Specifically now, I would draw your attention more towards one of the last photographs, 253, which is a close-up of a stab wound on the torso of Miss Jasmine Pace. Your Honor will see how it's yellow color. I anticipate that Dr. Cogswell will testify that in his expert opinion, that's indicative of a lack of blood in the system of Miss Jasmine Pace at the time that that injury, that wound, was inflicted on her person. That would indicate an approximate time or a sequence, if you will, of when that occurred during the 60 or so stab wounds inflicted on her. I think it's relevant and it should be allowed.
Mr. Morrison, I don't see any of the photographs necessarily being duplicative. Closest was photographs 230 and 231.
Your Honor, I'm happy to walk you through what we believe are duplicative.
Okay.
We'll start with 223. Our position is that 223 and 225 are similar in nature and show the same view of this case, same location.
223.
223 and 225.
Okay, so 223, I see both cuffs connected by a chain, the handcuffs. And 225, I see one cuff. So it looks like they are showing two different things.
Our position is that the bag is just over the foot. That's shown in 223.
Well, is that a hand that's also shown in 223?
Yes.
It's not shown in 225?
Correct.
Okay.
Going forward,
I respectfully disagree with the duplicative nature of those two.
okay, 229 and 230, Your Honor. You can see in 230, it shows an individual standing on a stool to take a photograph. 229 is taken at eye
Hang on
level.
just a second, Mr. Morrison. Okay, I'm caught up to you now. You said, so 229 and 230?
229 and 230, Your Honor.
And 229 looks like almost a horizontal picture.
It appears to be at eye level. 230 seems to be, you can see an individual's feet on some kind of stool next to it. They've taken a picture.
From above,
slightly
yeah.
above.
So, I mean, 229 does not show the victim's left side, while 230 clearly shows the left side. I don't think those are duplicative. The closest I thought were 230 and 231.
And our position is that 230 is less gruesome for the jury than 231 is. I agree with you that they are close in how they look, but 231 obviously has more blood visible than 230 does.
You know, I can see some distinctions between 230 and 231, but as far as the relevancy analysis that we're conducting now,
Yes, sir.
can you see that the bag is missing and the victim's head is turned from 230, it's facing up, 231 is facing more horizontally.
Yes, Your Honor, and so the court's aware of this photograph, 231, I believe it is, yes, 231 was not initially in our 12D2. However, if Your Honor will turn to 254, which is the other demonstrative exhibit that counsel was telling you about earlier, there is a superpositioning, if you will, of an autopsy photograph overlaid on top of a crime scene photograph. The outline of Jasmine Pace's body that Your Honor can see in 254 comes from 231. That's the only reason that it's relevant. I submit to the court that I would be inclined to agree to make this one black and white. Your Honor, it doesn't show the wounds to Miss Jasmine Pace, so I don't know that Dr. Coswell could opine as to the injuries shown on her body, but the outline of her and the position of her body specifically would be relevant for the purposes of comparison to that crime scene photograph.
Well, that's what I'd like to do before making a ruling on it. Just check with Dr. Cogswell, see if there is anything on this photo. Unless you're representing, you know for a fact, he's not going to be able to do that.
I think that the only purpose of that photograph, Judge, was for the demonstrative exhibit, for showing the relative positioning of Miss Jasmine Pace as she would appear on that piece of carpet that Your Honor sees in 254.
So are there any major distinctions between 231 and 230? If I hear you correctly, 231 could definitely come in as a black and white, but why would 230 need to be admitted if 231 was admitted?
Your Honor, I would be agreeable to strike that photo.
Okay. All right, let 231, the defense motion to keep photo 231 out be sustained.
230?
I'm sorry. 231 is coming in, 230, the objection will be sustained.
Yes, Your Honor.
Your Honor, going forward, 235, as the court,
Okay, thank you.
as the court can see in color, Mr. Sherwoyle did mention the Morris case. This picture does show Ms. Pace's eye quite open. It shows her eyeball. There is no injury there at the eye. Our position is that the picture in color showing her eyeball could be considered gruesome for the jury. It doesn't show any relevant evidence within that photograph, with the exception of the cut below her nose. Our position is that this should be black and white and that it should be redacted to eliminate her open eye in the photograph.
Your Honor, the state can submit that we would be happy to redact Miss Jasmine Pace's eyes. There'd be a black bar placed across the photograph at the top to basically bisect 19, where the colon is, would be completely blacked out, so it would just show the tip of the nose down to the base of the chin.
Okay. Defense motion to suppress photograph 235 be granted in part in that the color be suppressed and be either the photo be cropped or a black bar be placed across the victim's eyes.
Yes, Your Honor.
portion of Ms. Pace shown within it. When looking at 237, it is specifically injuries to her right shoulder and her face and part of her hand. Those same injuries are seen in 230, also in 240, the same head injury is shown as well as in 241. We are of the position that those are equally focused.
Looks like the ruler is placed at different places for those three photographs. I mean, what do you think, Joe? That's something we're...
Your Honor, I would submit that they are relevant, Your Honor. 237 shows what's described on page 2 of the autopsy report of, quite honestly, a litany of injuries, starting with the right side of the head and neck, numerous stab and incise wounds. It then describes with particularity upper forehead, near the hairline. It penetrates to bone, so on and so forth. So I believe that 237 is relevant. I would submit to the court that it's not unfairly prejudicial. The photograph number 240 shows specifically an injury described to the left side of the head has a wound. The left side posterior neck has an oblique 2 1/8-inch injury. That actually is not the same cut in number 240 that Your Honor can see across the center part of the photograph in 237. 240 is actually on the back of the head versus 240 being what I would describe as being near, slightly above the ear on the temple. So 240 actually shows a different wound, which is not pictured at all in 237.
So our argument then would be that 241 and 237 do show the exact same wounds, with the exception that 241 shows a greater portion of Ms. Pace's torso and back. With that being said, 237 is just a closer shot to the head wounds, which are all shown within 241.
Again, it looks like there's a ruler that's placed in two separate places in 237 and 241. 241, the ruler is placed near the victim's torso. On 237, it's placed on her neck.
And then while the ruler has moved, all of the injuries shown in 241 are the injuries that are contained within 237.
One difference, it looks like in 241, the victim's left wrist obscuring her face, her nose and mouth, while in 237 it's not. I don't know if that's relevant. Just looking for differences. You can tell me if that's relevant or not.
Your Honor, I submit that 237 is extremely relevant and highly probative of the injuries that I described on page 2 of the autopsy report. Number 241 shows a general overview, but most importantly, it begins to describe a series of injuries below the neck, Your Honor. So it provides context for the injuries below the neck. Additionally, Your Honor, you will note that since it's pulled out quite a bit, you no longer can see the coloration of the wounds. They're extremely clear in 237, specifically the subcutaneous tissues above her right ear, as well as the damage down the ear canal in number 237. So I submit that they are different and that they're for different purposes.
Mr. Morrison, it looks like the ruler is covering a wound in 237. I think your argument is that 241 covers them all, though. It like displays all of them.
It does.
I think the call very similar. They're not, there is a couple of distinctions as far as where the ruler is placed to give the jury a better idea, a less speculative idea of how large these spoons are. Again, if 241 were to be the only photograph that was entered, it would not show the bottom part of the victim's face with her hair underneath her. Looks like there's some coloring on her cheek as well. So this was a more close call, but I'm going to find that they are sufficiently distinct enough for an expert to point out the differences, which would be helpful to the jury. So the defense's motion to suppress 237 be overruled.
And are going forward to 238 and 238 and 239. You can see that that is 239 is shows an individual pulling Mrs. Pace's chin up so that there's a different angle of the injury that's shown in 238.
Looks like the difference to me, 238 shows an entrance and an exit. Perhaps, I don't know, 239 looks like it shows, if I'm looking at that correctly, a complete gap from one side for neck to the other. General?
Yes, Your Honor, that is what it shows. Your Honor, so for this, where this is one of the specifically enumerated anatomical findings of Dr. Cogswell on the medical examiner's report on page 1, was described as the major damage to the larynx, right jugular vein. So we can submit that is extremely relevant. It shows a complete perforation through the trachea of Miss Jasmine Pace, as evidenced by 239.
These photos are clearly distinct, and obviously the distinctions for these two have what seems to be obvious relevance. The 238 shows the entrance and what looks to be an exit wound, while 239 shows the some part of the internal aspects of the physiology of the victim. So the defense motion to suppress either 230 or 239 to be overruled.
Your Honor, and with that, the court has even indicated that you can see part of the internal organs of this case through that photograph. Would the court be denying our request to have this photograph in black and white?
I mean, I think that the general's argument earlier about discoloration certainly apply to this photograph in the sense that you can see both red and yellow. And if it pertains to the argument that was made earlier about when the blood flow actually stopped, it seems like this photograph would also be part of that same argument. I'm missing some generals at the same argument we made earlier.
Yes, Your Honor.
Okay. So let the defense motion to have photograph 238 to now be in black and white also be overruled.
Your Honor, and then there's another set of 3 photographs, and they are noted as 248, 249, and 251. And while this does show different angles in 248 than it does in 249 and 251, all 3 of these photographs are of the same main wound that's shown initially in 248. 249 shows that the wrist is slightly turned, and it shows a different angle. And 251 does show the underside with the palm up of the same hand that's originally shown in 248. So our position is that they are duplicative, those photographs.
So 249 is of the palm being up.
251 is of the palm being up.
Okay.
249 is of the palm palm being down, you see, there are 4 slashes there. 248 only shows the main one that is shown in 249 and 251.
And these are very distinct. 249 and 251 are separate sides, same extremity. 248, it looks like is one of the wounds shown in 249, but at a different angle. Again, as long as the general understand it, ME is going to discuss how these are significant as far as time of death and things like related to the damage that each one of these blows inflicted. Is that correct?
That's correct, but 248 is actually the only photograph that we have of an injury described on page 3 of the autopsy report of a superficial wound in close proximity to that large cut. Furthermore, the autopsy report documents the wounds to both the top and bottom side of Miss Jasmine Pace's left hand. Your Honor can see that while 248 does show kind of a side-on view, it does not show the damage or the number of wounds indicated on 249 to the top of her left hand, nor does it show in 251 the injuries to the underside of her left palm. So we would submit that they are all relevant, and also the color is necessary again for the same argument that's been proffered by the state. I anticipate Dr. Cosgrove will be able to apply as to the relative timing order, I guess, whatever the term the court would like to use.
Okay. I think these photographs are distinct enough from each other to show, while it's the same area, to show different relevant aspects of the wounds that were inflicted. But the defense motion to suppress some of the photographs of 248, 249, 251 be overruled.
Your Honor, related to, and I'm sorry to go backwards, but 243, 244, and 245 do contain angles that would show Jasmine Pace's chest. The state has provided us with copies in which they've been redacted. Our position is that 244 and 245 are duplicative of one another. They're just from a different angle. Both of those photographs show rough markings on Mrs. Pace's arm. You're able to see the same. You're able to see the same coloration in 244 that is shown in 245 for the rust as well as the marking as well as the same tattoo.
Looks like 244 is a larger picture than 245. I'm trying to see if there is anything different in 245 that's not captured in 244. Joe?
Your Honor, 243 shows the right chest with a 3 1/2 by 1 inch contusion. It's that large purplish area right below the black square, the redacted portion. Photograph 244.
You can just tell me the 243 is definitely distinct. You can just distinguish the relevance between 244 and 245.
Yes, Your Honor. 245 shows a right elbow with a 1/4 inch superficial incised wound, as well as, Your Honor, if you look, you take notice of the handcuff imprint with rusting on the right forearm. It does not appear in the photograph 244.
Ms. Morrison, I do see that now. It looks like 244 and 245 are distinct for that reason, and that 245 does show some type of ligature or something, I guess at the cuff mark, perhaps below or between, I should say, the tattoo and the marks left from the chain, and that's not in 244.
demonstrative evidence. There, within the ME's report, there's nothing that indicates that Ms. Pace was handcuffed while on the carpet. This is evidence that has, again, contains the signature of A. Smith, that is employed with the medical examiner's office. The picture that the court has allowed in, which was indicated as 241, sorry, I believe it's 231. Yes, 231 has been flipped and placed into this photograph. This is carpet that was removed from Mr. Chen's home, and that a photo of Ms. Pace has been placed on the carpet once it's been turned upside down. Our position is that this is overly prejudicial. There is not testimony to our knowledge. There's no reports that show that Mr. Coxwell's testimony is going to be that she was cuffed while stabbed. This does present to the jury the idea that that's exactly what happened. It's misleading, and it's unfairly prejudicial to the jury.
Your Honor, demonstrative exhibits are well recognized. Dr. Cogswell is a forensic pathologist. He's furthermore the medical examiner for Hamilton County. I would draw the court's attention and counsel to page 2 of the autopsy report, and I'll read it here shortly. Her right ankle is handcuffed, and this is in the evidence of injury general portion, about halfway through that paragraph. Her right ankle is handcuffed to her right wrist, and her left ankle shackled to her right arm at the elbow. The doctor goes on to continue with another paragraph. A total of 60 stab and incised wounds are present on the body, primarily involving the right side of the head, neck, upper back, and right arms. The injury locations are consistent with the decedent's fetal positioning as found. Your Honor, as a forensic pathologist, as the Hamilton County medical examiner, Your Honor can take a look at image 254. Your Honor will notice along both the left-hand side of that photograph, there's a yellow and black marker indicating inches. Along the bottom is a ruler also indicating inches. I think Dr. Cogswell, within his expert opinion, can make anatomical observations about the height and weight of Miss Jasmine Pace, the position of her body as found, and make comparisons to other items of evidence. In fact, Your Honor, experts are permitted under our law specifically to opine as to items that are submitted to them during the course of the trial. The state could put the picture, crime scene picture, up on the screen and ask Dr. Cogswell if that means anything to him, and he could opine within his expert opinion, yes, I believe that to be the outline of a human body. As you can see right here, there's this sort of an injury, the blood would flow in this general direction. I believe that's completely within the realm of his expertise as both a forensic pathologist and a medical examiner, and therefore he can say, in my opinion, that was the position of Miss Jasmine Pace at the time.
Morrison does seem like, again, this is coming in through an expert. They regularly make diagrams, maps, compilations of data. So this seems that would fall in the realm of an expert's ability to testify. Getting thoughts on it seems to fit with what we talked about earlier with the conglomeration of the suitcase photos.
Our position is it doesn't appear to be something that has been created by Dr. Cogswell. I mean, as indicated in the photo of 254, there's an individual that has the name of A. Smith, whose signature is there. This hasn't been provided to us through any report of Dr. Cogswell, but has came as demonstrative evidence from the state that they claim to put in. Our position that we have noted within the demonstrative, which I'm crossing over to the last motion, but I do believe that they're related. The photo that's being asked to be considered for the court shows a ruler. It shows a scale. There's nothing that we are able to do at this point to indicate or to confirm that these photos are in fact to scale. We have a photograph that's been enclosed to a carpet that has a ruler, and the dimensions are showing that one photo is potentially a 282% while another one's at 560% if you were to go off what Mrs. Pace's actual size is. When you're looking at that, there's no question that it can be confusing to the jury, especially when one photograph has had to be shrunken almost half of the size of the other one to make it work. Also, if you look at the photograph where Jasmine is there on top of the carpet, you would have to be looking at her because the right side's up in this photograph. As General Moyle just indicated from Dr. Cogswell's report, the injuries are from the right. So that would mean that she would need to be laying on the right side for the blood to be there. It just doesn't make sense. It's confusing. I believe that the state has created a demonstrative evidence, or a photograph to use as demonstrative evidence that goes against what the report of Dr. Cogswell says that his testimony would be, and it is only to inflame the jury. For them to see Ms. Pace laying on a blood-stained piece of carpet, and for them to be asked to believe that she was stabbed while shackled, which is not in the report. There is statements of fetal position, but there's nothing that indicates that she was shackled at the time of the assault. It is creating ideas for the jury that are not in existence in evidence.
As far as her being stabbed while being shackled, that I didn't draw that conclusion from looking at this. There are lots of ways it could have happened. She could have been stabbed.
The photo does show the cuffs at her feet.
Sorry?
The photo does show the cuffs at her feet, the shackles.
And I can see that from this photo that has been superimposed, it's obviously one where she's been shackled, but superimposing it over this blood pattern, that doesn't necessarily mean that's where she was stabbed. It might have been where she was brought after she was stabbed. As far as the right side versus left side, the wounds may be on the opposite side, but the blood would obviously run down to the carpet. So I don't know, I don't think there's any conclusion that can be drawn from this photograph at all, much less an unfair one, other than that her body happens to match that particular pattern of blood. The way the blood got there, when it got there, when she was shackled, that's all speculative. I don't think this photograph necessarily invokes any unfair speculation on the part of the jury. Let me ask you this, I think you said it earlier, but the A. Smith individual, is that an employee of the medical examiner's office?
Yes, Your Honor.
Okay.
I think she's considered the forensic assistant.
And she's not on the witness list.
Well, she's an employee of the medical examiner staff. I mean, this is a demonstrative exhibit coming from the office or the expert that's going to testify works. So I don't see any substantial danger of unfair prejudice outweighing the probative value on this one. The jury would see it, in a PowerPoint closing or even while the expert's testifying anyway. This was created by the expert's office, so I don't think it creates the danger of any unfair prejudice, at least not to the degree that it substantially outweighs the probative values of the defense motion to suppress photograph 254 be overruled.
Your Honor, and to just follow up on that, related to General Coburn, Dr. Cogswell being an expert, we haven't received anything that shows that Ms. Smith does have any expertise to create such images that has been created, and that is the basis for our motion in the demonstrative, dealing with demonstrative exhibits, and why they should be suppressed.
Well, Dr. Cogswell can certainly explain that. About it, there are rulers in some tape that marks off distance. And I think that's something that Dr. Cogswell can explain. I don't think you need to be an expert to superimpose something. You just need to be an expert to explain its relevance, which I think Dr. Cockrell is going to do. So I don't think that creates another basis to suppress this photograph. So again, but the defense motion to suppress photograph 254 be overruled. Any more from these photographs, by the way, we can talk about?
No, Your Honor.
From the defense?
Not from state.
Your Honor, just, so we have the ruling as to the photographs in general, but our question for the court related to the demonstrative evidence of 254 is if Dr. Coxwell did not create it, and we don't have any reports from him related to it, how is it exactly that he's going to be able to potentially?
His office created it, whether his assistant created it, whether his computer program created it, whether some other tool or individual that works under his direction created it. This comes from the medical examiner's office. So I do believe that.
If he's not able to testify about where it comes from, how it's created, we would obviously still have the ability to object to its validity and its admissibility at the time of the trial, correct?
I think the witness would certainly have to lay a foundation for it to get into evidence, whether that's looking at the name, person who created it, describing that's in her usual job or job description. She usually creates these types of things at his request or not. So yeah, you can certainly renew any type of foundational objection at trial. You don't think it's been met, we can talk about it.
Thank you.
And I guess that was the demonstrative evidence. That was a separate motion. Ms. Morrison, is that correct?
It is, Your Honor, and within that, obviously, we have argued that a McDaniel issue may arise related to this, so that may be something that we would need to take up outside of the presence of the jury, related to Dr. Coxwell and his knowledge of the photograph and how it's created. Okay.
Would you be attacking the methodology or the expert qualifications or both?
Both, I believe. I mean, at this point, Your Honor, what we have is a photograph that's been provided to us that was created by A. Smith. We know that she's an employee of the medical examiner's office. That was not included within any of the reports that we received subsequent from Dr. Coxwell. Any information from Dr. Coxwell related to this picture that's created by an employee of his. I have not seen a photograph created by A. Smith in any of the homicides that I've worked in the years that I have been in the system. So I do have questions about what Dr. Coxwell's knowledge is of this. The state has put in their response that they intend to offer this as evidence through Dr. Coxwell. They do not intend to have Ms. Smith here. Maybe because Ms. Smith doesn't have the training or knowledge to have created it. We don't know. But we do plan to have Dr. Coxwell explain to us what information he knows of this, if it's accurate. The scales, as I've mentioned to you earlier, are about 200% off when you're looking at it and breaking it down. So there are things that would need to be addressed more than likely outside the presence of the jury.
We can certainly do that. If it turns out that Mrs. Smith just on her own did this and snuck it in there and Dr. Coxwell has no idea what it's about, then you can renew your objection.
Okay, thank you.
The last one I have is the video with the defendants dressed in jail attire. Is that correct?
That's the state's motion to money.
Your Honor, if you can, connect this to prosecution laptop. So to preface, Your Honor, this is a video that's around an hour long. It is days after Mr. Chen has been arrested the first time. The police department, I believe there will be testimony that they needed to get a possibly better fingerprint sample from him, and maybe DNA as well. I think this is where they take care from him. So they transport him from the Hamilton County Jail to the Chattanooga Police Department, which is where he's sitting right now. He waits for a period of minutes with this officer who has a body cam on next to him, and then he can be seen being fingerprinted by individuals in the CSU unit at the Chattanooga Police Department. We filed a motion to be able to use this. We think it's relevant. Case law would indicate that while a defendant has the rights to appear before a jury during a trial in plain clothes, there are numerous cases throughout the state, both the Court of Appeals and the Supreme Court level, that opine that the jury seeing the defendant for a short period of time in jail clothes is not overly prejudicial to the defendant. In one case, State versus Jones, the jury saw a 2-hour video, and the court found that that did not serve as a quote constant reminder, which is often the standard that's used, that the defendant was in custody. There's also cases that note that juries are not stupid. They understand that the defendant did not get here voluntarily or by his own choice. If you are charged with or accused of first-degree premeditated murder, you have been in jail at some point. Overall, this video serves multiple purposes. None of the purposes have to do with him being in jail clothes. It's for other evidentiary issues. So it's about the first 20 to 30 minutes that the state would be playing, even though it's an hour long. We can do that. I can sort of fast forward through it. It depends on how Mr. Weiss wants to do it.
What's the relevance?
The relevance is twofold, Your Honor. First of all, Mr. Chen makes statements to Officer Frantum a few minutes into the video. Secondly, the state has to prove that the fingerprints that were examined by the fingerprint examiners were actually Jason Chen's fingerprints. So there has to be a connection made, or the defendant can make the argument, well, the fingerprint examiner is saying that this card matches Jason Chen's prints, or the card matches the prints on the trash bags that Ms. Pace's body were in. However, we have to verify that the prints on the card are Mr. Chen's prints. The defense could certainly stipulate to that, but there are statements made by Mr. Chen that the state seeks to play for the jury.
Sir?
I don't believe I ever received this motion.
I'll have to go back to my email, Judge, but we actually talked about it too at the police department.
I remember chatting about it, but I don't remember.
That was filed December 13th.
So,
While Mr. Weiss is reading that, I was reading your motion. See that demeanor was mentioned in the motion in reference to another case. Just assumed that was why you included that language, that demeanor was part of what you wanted this video to show. Is that not correct?
Well, Your Honor, not necessarily. I believe that the defendant's statements could be considered by a juror as inculpatory. We can play those if the court would like.
That's okay. We'll play whatever you think is relevant for sure. I just didn't know if demeanor was something I should be observing.
No, Your Honor. I would not say that demeanor is a significant issue in this video.
Thank you.
I don't have a copy of my email. I'm not going to say that doesn't mean I didn't give it to you, but I do not see where I emailed it to you. If the court didn't hear that, I do not see in my email where it was emailed to Mr. Weiss and Ms. Morrison. Of course, we've seen them outside of emails, but certainly, Judge, if they need more time to review this and potentially respond to that.
Okay. We're going to be in court a few times before this gets played. So, Mr. Weiss, why don't we give you some time to look at it, try to review it, and
You can have that.
court in this case in Hamilton County will be the Monday of trial. So we can take up this motion at that point if it's contested. And then you can look at it in the meantime and decide if you want to contest it.
Yes, Your Honor. And just so I understand, which video is this?
This is Officer Franklin's video, Your Honor. It is on our Rule 12 notice. And it specifically is, I think, entitled the video.
Yes, Your Honor. If I could just have time to look at that and respond.
Okay. All right. Anything else on this matter before we meet in Nashville?
A couple issues, Your Honor. First of all, I want to make note that we've brought this TV in here. We've noticed, and we actually tested it out, that when it comes to Blue Star photos, which is the agent that reacts when it is sprayed on top of blood, cannot really be seen well from our projector. We've experienced this in trials before. It's just the way that the projector is. So the TV, we would ask that we be able to use the TV with the jury with the Blue Star photos because it appears. So I wanted to make note of that, is what that's doing
Any
here.
objection?
And then the court will remember, we brought the issue to the court about the defendant's text messages containing potentially attorney-client information. The court has reviewed those records. The state has sort of had its hands tied. We have been waiting and assume that we are going to get today a PDF version, PDF version of the redacted text messages. I know that Mr. Weiss has had trouble, we've communicated about this, has had trouble trying to figure out how to redact that information that the court did find the state would agree with the attorney-client privilege. Apparently you cannot redact things out of Cellbrite, which makes sense. So I believe our newest idea is that Mr. Weiss is going to print all the text messages in PDF form, make certain redactions to them, and then give them to the state to review. That part is fine, except for we would like to have access to the other potential evidence or information on the cell phone that is not text messages. So I mentioned to Mr. Weiss that I was going to draft an order for the court to sign that indicates that the state has the ability to go through Cellbrite to look at any information, documents, data that doesn't have to do with the text messages. We would agree to not look at the text messages except for the PDF form that would be redacted by the defense attorney. That's the only way we could sort of see moving forward how we do this, because we have evidence in this case. In some cases, this evidence is very significant. What's on a defendant's cell phone sometimes could be the crux of the case. I'm not saying it's going to be in this case. I'm not saying we're going to use anything. But at this point, we have evidence and our hands are sort of tied. We can't even review the evidence. And so I've got the order here, but for the court to know, we don't have any of that. We've not, obviously, looked at any of the Cellbrite data, but we would like to.
There are a couple of ways we can handle this. We can handle it the way that the parties have worked out, which is historically, whenever I make a suggestion, I always circles back to, let's do what you suggested in the first place. But that being said, from the in-camera review, it seems like only a handful of text messages could be considered protected, clearly protected between Mr. Chen and someone who's talking to him with attorney-client privilege. I don't recall anything in those texts being inculpatory in any way. We don't have to get to the substance of those, but I don't think there's a risk to Mr. Chen's constitutional rights being violated if the state were to just look through Cellbrite information without getting into the text messages, even though they could. They would. I don't think there's a risk of that in this case. Want to be heard on that?
I believe that the court will order it. The general, or both counsel here, are members of the bar, standing, and I would, as officers, support trust them to not look at those text messages. And in fact, we even agreed if they were. We've been through the phone. We didn't identify anything else that could be protected by attorney-client privilege. But just so happens, if we were to miss something, we even agreed that that would not be
anything that I saw that was inculpatory in any way that would have been covered by attorney-client privilege, I would not feel comfortable saying that, but I do feel comfortable saying in this particular case that I don't think there's any risk, but General, as you know, you can't look at or use anything that's attorney-client privilege. So at this point, I think the ruling would be you can go ahead and start looking at the data, stay away from the text messages. Okay.
Would you like to sign an order, Judge, or is that just a rule from the court?
I would just like to review it before, I mean, we can have signed tomorrow for, let me review.
Okay.
Just two other housekeeping issues. There was a lot of objections today that were overruled during the course of the trial. I don't feel like it's necessary to extend objections to the hearing. So if the court would take, I don't know, judicial notice that the defendant has lodged an objection to the evidence that would be admitting it.
I read over the case law to where the appellate courts say you don't have to keep renewing your objection for it to be preserved for the record. So I think you're safe in not objecting. You made very detailed objections and the rationale behind them, so that should be protected by the record. But if there's any doubt, you don't have to make those objections; those are preserved.
And then lastly, if the court would allow Mr. Chen to be with his parents back in holding cell for 10 minutes.
I've typically done that. You don't have any problem with that?
No, Your Honor.
Okay. All right.
That's it.
Okay. Again, if anything comes up between now and then, we have each other's text. You know, we get text thread. We'll have to add Ms. Morrison to our text thread for sure. But if anything comes up, just let us know, and we'll try to solve it. Otherwise, I'll see you in Nashville Wednesday morning.
Your Honor, do you have any more information about the jury assembly room or courtroom that we are supposed to head towards, or do we just communicate?
We're
As we
using
go.